Proceed.
No, Your Worship.
Okay. All right. I also recall in your testimony that you were able to get, in terms of your investigations, you found special powers of attorneys in which my client grants that special power of attorneys to Mr. Elindi. Did I hear you correctly?
That's right.
Okay. If you recall, I remember you stating the date of that special power of attorney to be different from the one we attached in his founding affidavit. Is it a different one that you found, or is it the same?
I don't remember putting a date to
Okay.
that record.
Okay. The reason why I'm saying that is because the special power of attorney that we attached was not part of the disclosure. But in your investigations, you found a special power of attorney at the bank, isn't it?
Yes, that dates back as far as 2020, if I'm not mistaken.
Okay. And then in addition to that one of 2020, let me just make sure, sir, before, because I don't want to mislead you. Thank you. In addition to that special power of attorney, we also attached one dated 27 June 2022 to the founding affidavit.
I'm not sure whether it's...
Just a moment.
27.
27 June 2022. That is annexure LSN 6. Immediately after the BIPA documents.
Sam, what is your comment?
Your Worship, I'm not sure whether it's the same records that we have. And I haven't had a view, or rather a look at the document which the council is referring to. But I know that there were some later power of attorney and resolutions that were made. I think I might have, in terms of the records, maybe 3 or so.
Okay, that's even better for me. So one of the powers that would have been, or that were granted to Mr. Elindi Austin by the members of the CC, including my client, is to conduct electronic fund transfers on the bank accounts of Enercon Petroleum CC.
That's correct.
Okay, is that also what you found in the other ones?
That's correct.
Thank you. Okay. Mr. Inamba, I want to make a proposition to you. In your opinion, or rather, let me ask, in your opinion, a charge under the Anti-Corruption Act, a charge of acquisition or possession or use of proceeds of unlawful activities, money laundering, is that a serious charge?
It is a serious charge. I don't think any charge is a less serious charge. These are serious charges that we have.
Furthermore, sorry, you are not done, sir.
And I'm sure if we go to that piece of legislation, it will provide the actual penalty in that regard. So it is a serious offense.
Furthermore, a charge of money laundering under the Prevention of Organized Crime, specifically contravening section 4B, subsection 1 or 2. Is that a serious charge in your view?
Yes, it is.
Okay. Furthermore, a charge under the Anti-Corruption Act of 2003, one of dealing with or using or holding or receiving or concealing gratification, specifically in terms of section 45, 1B, do you also regard that as a serious charge?
Definitely. I mean, we have already gone through the penalty prescribed in the Anti-Corruption Act, which is 500,000 or 25 years or both. So it is serious.
And then a charge of conspiracy under the Anti-Corruption Act?
The same, serious.
Okay. So those are the charges against Mr. Connie van Wyk, who's out on bail.
You didn't specify those charges were for, I mean, for which accused. You asked me the seriousness in respect of the charges.
Yes, now I'm putting something else to you. We are done with that. I'm putting to you that those are the charges against Mr. Connie van Wyk, who is out on bail as we speak.
I haven't testified on the charges of Mr. Connie van Wyk since I started in this hearing.
Okay, that's your answer.
Yes.
Okay. Okay. According to my notes, I just want to confirm, or let me just leave it. It's not necessary since it's not in dispute. I want to make a proposition to you. Please indicate to me if you agree with it or not. You are welcome to elaborate the reason why you agree or not. The proper approach, Mr. Inambao, in our jurisdiction in deciding the risk of interference with state witnesses or investigations itself is to ask whether it is likely that the applicant will interfere, not may interfere.
Must I comment?
Yes, I'm inviting your comment.
Your Worship, the likelihood of interference is high. As much as, you know, the transactions that were indicated were done by internet banking. In terms of the evidence, Your Worship, if you go onto the account statement of Erongo, you would find that there's also a lot of cash deposits. As much as Mr. Nandaho may not have had access, in terms of the cash deposits that were made onto this account, they were being made by him. And as a result of those deposits, money was paid. So, and hence I indicated that, you know, if you follow the chain of all the accounts that you have showed me here, it's moving from one account to another. There's even cash deposits and so forth and so on, which carries elements of money laundering, which makes it complicated. So the risk of interference is high at any level.
So that's your answer to the proposition that in this jurisdiction, the proper approach is whether an applicant will interfere, not may interfere. Is that your answer, sir?
Definitely.
All right.
You know, as far as the cash deposits I've seen, and we are still receiving even more deposits and withdrawals, I can even put a value of at least over 300 million, I mean, not 300, 3 million, which I've seen Mr. Nandaho depositing on the account.
You've seen him deposit 300 million.
In terms of the withdrawals slip. the funds
You
that
saw
he
him
withdrew.
withdrawing?
No. In terms of his signature.
Oh.
So he's
Okay. Okay. If you have regard to counts 60, 61, and I see now that we were told he's only charged with 60 and 61 by the state. There should be an error, but let's include 62 as well, because we see it now in the bundle of, because the charges were changed later during the proceedings. We were given 60 and 61. We'll clarify that with the state. If you have regard to that, sir, and please take your time, you are under no pressure. You will agree with me that there is no reference to Mr. Nandaro being charged in his capacity as the member of the close corporation. The closest they get is to something called representing, but they don't make reference to his membership under the Close Corporation Act.
which of the charges do you want me to refer to? 60, 61, because I see there's a 62, which is twice here, 62, 62. Which one do you want me to?
Yeah, that's the confusion that is here. But me, I was clear. Look at 60.
Mention 62.
Yes.
Yes.
60, 61, and it's alternative, and then 62, just to be clear.
Yes, I'm saying
just to
there's
be thorough.
two of 62. So which one of them must I look at? All of them, both 62? Because there's two of them. I don't know whether on your document they're like that. I'm having 262.
Sir, 62 has an alternative count because it has a main count. So there will be two, sir.
Okay, sure.
So what is your comment? Okay, take your time.
Yes, thank you, Your Worship. Just reviewing the. The only charge, Your Worship, where I'm not seeing a wrongo listed is count 60.
The question was that on count 62, there is no reference that applicant number 7 is charged in his capacity as a member of the CC.
Yes, Your Worship, I see that, but as I earlier and as I've been indicating already, it's preliminary charges, and we know in terms of the evidence that we have led, it was to indicate that he was at that time the member. That is how the evidence was led.
So, Mr. Inambao, Mr. Nandaro has not interfered with the investigations, and he is not likely to interfere with the investigations. What is your comment to that, if any?
That's what you are saying, but I've indicated that as far as money laundering is concerned, you can see how the money was moving from one account to another. There's at least 3 to 4 accounts that are involved just to execute one transaction. It moves from Erongo, it goes into quality meat supplies, then it goes. Those are the complexities of money laundering. And as far as we are concerned, it's very easy. And as we are saying, we are still investigating. And as we are indicating, cash withdrawals were made. And there's a lot of leads that we can still find out and establish to see where this cash actually went.
Mr. Nandawe is not charged with money laundering, sir. And in addition to the interference issue, the applicant, Mr. Nandawo, is prepared to abide by conditions of not interfering with witnesses if their identity is made known to him. Sir?
I'm looking at count 62.
He is actually not charged with 62.
Counsel, can you just allow him to respond? Yes. Sir, do you have any comment?
Yes, Your Worship. She's saying he's not charged with 62, and I'm seeing 62 here. Your Worship, and 62 is contravening Section 4. So.
Sir, he was only charged with 60, 61, and its alternative. That is the charge sheet we were given. This charge sheet was given prior to him appearing on the 14th to move his bail application. But that is something we will deal with the state. It's not your problem.
Of course. For me, I'm looking at the charges which are here, and I'm seeing money laundering there as well.
Now, let's go back to the question that I asked you after that one.
Your Worship, it's not an objection, but it's just to put the correct version as that relates to the charges. I think from the onset, Your Worship will recall that these charges were amended. Yes. So to say that the seventh applicant is not charged with the offense of money laundering, I don't think it's the correct version as per the charges, because count 62 actually relates to money laundering.
Your Worship, if I may assist my colleague, that is Mr. Namanje's bundle. You will recall, Your Worship. When we came on record, we were given 2 charges by Ms. Hinda. We have a copy of it. When that bundle was exchanged, we were not in these proceedings. But I will deal with that in argument, like I said.
Then we can move on.
Yeah.
If you think you will deal with it during us, it's fine.
Mr. Inambao, my client I was putting to you that my client is prepared if the identities of the witnesses or potential witnesses are made known to him, whether he knows them or not, he is prepared to ask this court to set a condition that he should not have any direct or indirect contact with those witnesses.
We are saying in terms of the evidence, there's multiple transactions. His entity received 238 million for fuel. To date, that has not been recovered. So there's still a lot of things, and hence we are saying in terms of money laundering, you see the value that is involved, it's quite significant. So there are so many things which investigations could still find out which he can go and interfere with.
Before you proceed, the court will just briefly adjourn. Warrant, can I?
looking for the best in local
Yes, Mrs. Gebhard, I'm not sure whether you want to proceed due to time.
Amit, you're messing, Your Worship.
Yes, can we roll the matter?
Your Worship, if I may.
Yes.
There was a suggestion that we conclude today with cross-examination as well as re-examinations because the parties wanted to do submissions tomorrow.
Yes.
Because there is another bail application that is starting on Thursday.
Yes.
And but that is up to the court, but it's just a suggestion because we are seeing that time constraints, we won't finish. And she was saying she's almost done.
Yes, but that was the agreement.
Yes.
Or the discussion.
Yes.
And I have intimated that I see us going to Wednesday, but everyone was adamant today.
Yes.
But looking where we are now, and re-examination.
Oh, okay.
Yes.
It's in order then, if the
Yes,
court is of
but
the view that we
maybe
should
while we are there, that is why I've indicated that I wanted to see you all councils in chamber in the morning. It was about this because we are already behind our schedule.
Yes, Your Worship.
And I have other commitments. That is what I wanted to raise.
Yes, Your Worship.
Yes, more especially on Thursdays, because I'm already engaged in the other bill, and we have already agreed by last week. We are proceeding with that bill earlier in the morning. So that is why I've indicated that I wanted to see both councils in chamber so that we can discuss the way forward.
We'll be there, Your Worship.
Okay. So we stand down the matter, we proceed. I'm considering starting at 10.
tomorrow.
That's
Yes.
in order, Your Worship.
It's in order.
It's in order.
Yes.
In view of that fact, Your Worship,
I don't want us to discuss it here, otherwise we can still go to chambers when we stand down and then we can discuss.
perhaps that would be appropriate,
Yes,
Your Worship,
yes.
as court pleases.
Yes. Say you are still under oath. Applicants and accused, the matter is rolled to tomorrow to proceed at 10. The court adjourned.